Kathy Solom is with us today on Money Matters, and we're going to talk a little bit more about estate planning. And Kathy, this is a topic we visited quite a while ago, and
Yes.
we can hardly brush the subject here in the
Sure.
amount of time we have. So we're going to talk a little bit more about it. If we have our estate plan already figured out, how often should we revisit our plan? Does it need to be revised at any point? So what are some of the factors that we should consider if those kinds of changes and decisions should be made?
Just starting your estate plan is just the beginning, as you mentioned. If you have experienced major life changes such as a marriage, children, special needs child, if you change jobs, move out of the area or a different state, if you come into some wealth, if there's a death of beneficiaries or divorce, these are times that you might want to change it. Otherwise, every 3 to 5 years, you might want to consider looking into it. Things like tax law changes may have occurred that would affect your estate plan, or estate tax or estate laws may have also changed and require you to change some factors in your estate planning documents.
What about concerns over taxes? Are there things that we can do to help lower the tax bill for our beneficiaries?
When the federal government raised the limit to $5 million a couple years ago, and it is adjusted for inflation, so it's a little over $5 million now, that may have decreased who the estate tax affects. However, Minnesota is still at $1 million, so we do have some concerns with our Minnesota people as to how to lower that estate bill. Some of the things you can do to lower your estate bill is you can do an annual gifting program. You can gift annually to your children, your grandchildren. You and your spouse could give, and the current amount is $14,000 per person. So you could do that. You could also give away to charities. You could set up 529 educational plans for your children or grandchildren. So these are some ways to reduce that estate. The other thing, if you are married, you can do some things like splitting your assets more evenly between the two spouses. There are estate planning things we can do, techniques we can use to also do this. The other thing you want to look at is income tax ramifications from your estate. Tax deferred assets like retirement plans, IRAs, 401ks, and annuities all have income tax ramifications that you want to look at. Who's the beneficiary? Maybe you want to give some of these to charitable organizations where there wouldn't be an income tax effect on them.
Explain what a living trust is and when we may want to consider this option. And how does it differ from a will? Is it better than a will?
A living trust is actually one you set up while you're alive versus one that is set up through your will at death. So basically, during your lifetime, you set up a living trust, a revocable, which means you can change it during your lifetime. You would title your assets in the name of this trust. So upon your death, you can distribute those assets just like in a will according to your wishes in that document. You can give it to your spouse, your children, charitable groups, however you want to do it. You could leave it in trust for your beneficiaries if they are younger as well. The living trust has some advantages over a will in that you don't have to go to court for this, so you don't have to have it approved by a court. You don't have to go to probate is what they call that. You also, this information is not going through the court, so there are no public documents, so it's more confidential than that. Cost may be about the same because whether you have a will or a trust, somebody still has to administer the assets, distribute the assets, so there's still a cost involved either way. And the time also, again, either way you do it, you have to pay out the assets in the trust, pay the bills, and administer the assets. So there are some advantages to a living trust.
Now, a very important part of our estate planning is to choose the trustee. How do we go about finding someone to fill that role?
Basically, as long as you're of legal age and capacity, an individual or a corporate entity such as a bank trust department could be a trustee. The things you want to look for when you're looking for a trustee is, do they have the time, the knowledge, and the expertise in the various assets such as investing, tax laws, do they have the ability to keep detailed records of principal and income and how to distribute those assets, where the assets are, gathering all the assets, and also there will be claims to the estate and they want to make sure that they verify those claims are valid before they pay them out. So you're looking for somebody who's got capacity and time and willingness to do these type of things, whether it's an individual or a corporate bank trust company.
Well, Kathy, thank you so much for joining us today and telling us a little bit more about our estate plans and how to keep them up to date.
Great, thank you.